Shall we start? Yeah? So hello everyone. So thanks for attending this session. And I'm more than glad to moderate this fantastic panel with dear colleagues to discuss the regulatory and governance fervency, globally speaking, on AI. Too much has been said in terms of address some kind of regulatory interoperability and how we are seeing not only soft laws flourishing, but also hard laws being proposed, such as the Brazilian draft AI bill and also the EU AI Act, but also the Canadian proposal, also the Chile proposal. So the main, let's say, task of this panel is try to organize the basic concepts and the foundations of those regulatory conversations, and also try to identify what are the similarities, but also the difference, considering that we are going to face different challenges, but also opportunities to govern AI instead to be governed by such technology. So I have the pleasure to have Alessandro Manteleiro, professor of Polytechnic University of Turin, Elora Fernandes, research at KU Leuven University, also my dear friend Laura Cabrera from Center for Democracy and Technology, and also Carolina from the European Center for Non-Profit Law. So we were going to try to address this issue and also in a transatlantic conversation. So I'd like to pass the floor to Elora. And Elora, you have been conducting several researches with regards how we can have AI as another regulatory piece to address vulnerabilities in a broader way in order to reduce those kind of asymmetries instead of reinforcing those kind of asymmetries. So one of core issues is related to how AI regulation deals with such kind of vulnerability and also underrepresented groups. Could you provide a comparative analysis between the provisions of EU AI Act and also the Brazilian AI draft bill that is being right now discussed in the Brazilian Parliament?
Sure. Thank you so much, Bruno. I hope you can hear me. So first of all, thank you so much for the invitation to be here with such outstanding people. So first of all, what is vulnerability? The Brazilian bill has a very interesting definition of vulnerability, now in the latest version, which is understood as the recognition of the aggravated asymmetry of information or power of natural persons due to their cognitive, social, ethnic, economic, and age conditions, such as children, elderly, and people with disabilities. So here, of course, it's just examples we could include, for example, migrants, employees as well. And we're talking about aggravated asymmetry of information or power, so we should understand that this happens to all. And all human beings have, they are vulnerable somehow. But, of course, one of the reasons, this is one of the reasons that the initiatives exist, but we recognize that some people, such as the ones that I mentioned, also have an aggravated vulnerability. They have this extra layer of vulnerability, in the words of Professor Malgeri. So vulnerability is also contextual. So what are the key provisions in both initiatives that try to address and recognize these kind of extra layers of vulnerability? I think the first thing to mention is the prohibited AI practices. So in the AI Act, for example, we have Article 5.1b that prohibits AI systems that exploit vulnerabilities. And here, unfortunately, we're only talking about age, disability, and socioeconomic status in order to distort their behavior, likely causing significant harm. In the Brazilian bill, it's a little bit narrower because there they have to behave in a manner that actually is detrimental to their health or safety. So we're not talking about any fundamental rights, we're talking about only health and safety. The Brazilian bill also have a very interesting provision, which is the prohibition of AI systems that enable the production, dissemination, or facilitate the creation of material that characterizes or represents child sexual abuse or exploitation. And here, of course, the text is not the final one, but I'm really curious to see how we're going to enforce this, actually, because we're not talking about an AI system that by itself has this specific feature, but that we're talking about any AI system that actually enables a deployer or final user to produce this kind of material. So here we can include any image or text generation that enables this kind of material to be produced. So this could be either non-enforceable at all or enforced in a very broad way. So I'm curious to see how this is going to end up being enforced. Other two important prohibitions is emotion recognition. In the case of the AI Act, we have the prohibition for the workplace and education environments, unless it's for medical or safety reasons. We don't have this prohibition at all in Brazil. And also biometric categorization systems to deduce or infer race, political opinions, etc. This is also not, unfortunately, prohibited in Brazil. When it comes to high-risk AI systems, and here I'm mainly talking about Annex 3 and the standalone systems, originally the Brazilian bill had a similar list, but in the current version we only have the criteria that the competent authority should use to regulate these high-risk AI systems, which include vulnerability. And this list is more or less related to the list that the Commission has to use to extend the Annex 3 list, plus a list of contexts. And then there in the list of contexts that they also should take into consideration, we have more or less this alignment between Annex 3 categories. And there are some important categories that we should consider when we're talking about vulnerability is, of course, biometrics, as I mentioned, education and vocational training, employment, workers' management and access to self-employment, access to enjoyment of essential private services and essential public services and benefits, such as creditworthiness. We're talking about people that are economically vulnerable, and of course, migration, asylum, and border control management. And finally, I would also like to talk about the rights and obligations that we have in the Brazilian AI bill. There we have a very interesting and beautiful provision, which is Article 2, which is the fundamentals. So every AI system has to be developed according to these fundamentals. So here we're talking about protection of vulnerable groups, but also human rights, democracy, environmental protection, centrality of natural persons. I wouldn't say that these fundamentals are fully implemented throughout the bill. So we're talking about the prohibitions and the high-risk systems especially, but at least, of course, they're there and they're part of the operative text, because I see that this language is part of the AI Act, but mostly within the recitals, which could help us interpret the Act, but are not binding. And finally, in the section that is focused on the rights of persons affected by the AI systems, we have a very, very interesting and my opinion, powerful provision in the AI bill, which is that AI systems that are designed for vulnerable groups, such as children, the elderly, and people with disabilities, will have to be developed and implemented based on their best interests, which is something that I've never seen before, basically extending the principle of best interest of the child to the other people that are vulnerable somehow. I think in the AI Act, the provision that somehow most approximates this is that in Article 9, Paragraph 9, it says that when implementing the risk management systems, providers must give consideration to whether the high-risk AI system is likely to have adverse impact on children and other vulnerable groups as well. But I wouldn't say that it's not that powerful. And of course, these are just examples of the state of play. We can discuss this further if necessary. Thank you.
Great. Thank you so much, Laura. So very interesting the way that you frame it, because if you establish a comparison in terms of legal grammar of both regulatory initiatives, we could see also some possible ways to measure if those legislative or regulatory initiatives conciliates better or not a risk-based approach with a rights-based approach, and trying to highlight this importance of the Brazilian movement in order to draft this umbrella terminology, which is vulnerability. So possibly opening the venue to identify some dialogue between the future regulatory AI initiative with others, such as consumer protection, such as the legal status for children and adolescents in Brazil and so forth. And you touched also the importance of enforceability. And then I'd like to move to Professor Alessandro, because one of the main tools in order to trigger effective governance is the so-called human rights impact assessment, or in the Brazilian draft bill, the algorithm impact assessment. So, Professor, could you establish some comparative analysis as well in this regard?
Thank you. Thank you, Bruno. Thank you. I'm very happy to address this topic, also because we had the opportunity to collaborate on this topic with regard to the Brazilian regulation. I think that there is a quite significant distinction between the Brazilian and the European approach on this topic. Regardless the fact that all the EU institutions are very committed in order to protect fundamental rights, when we discuss the AI Act in Europe, only the European Parliament stressed the point of the importance of introducing a fundamental rights impact assessment. And the other co-legislators were against this kind of proposal. I work with Benny Fay and his team on that, along with other colleagues. And we have also to ask to many colleagues in the academia to support this introduction with a public call. So it's quite unusual, we can say, that European institutions so focus on fundamental rights, also based on the Charter of EU, then are sort of concern in terms of implementation in the regulation of this kind of tools. And it's not the case that while in the Brazilian AI Act, the impact assessment is for all the AI system, in the European AI Act, the fundamental rights impact assessment is just for a specific sector, credit scoring, insurance profiling, and the public sector or private entities that work behind the umbrella, we can say, of public task. So it's a more limited approach that, of course, is something that we as fundamental rights and human rights scholars do not appreciate in the European approach. So it seems to me that while in the Brazilian, since the beginning, also when there was the activity of the Senate Committee, etc., and the Committee of Experts, there was a focus on fundamental rights protection. In Europe, fundamental rights protection was just something raised by the European Parliament, but for us it's just a matter of product safety, product security, standardization. AI is represented to a large extent as something that deals with irons, cars, or very stupid things, while the big issue is the impact on society and individuals, as demonstrated by all the AI applications, all the most critical applications in the field of AI. So in this sense, I think that our model that focuses more on conformity assessment, so focus more on standardization than on fundamental rights impact assessment, is a problem, such as is a problem that the impact that the obscure trilogue procedure had on the proposal from the European Parliament. The Article 27 in the final text is bad written, contradicts the main logic of fundamental impact assessment in some aspects, such as this strange idea of materialization that is wrong, and also introduce in paragraph 5 this nice idea of creating a template of what? Because fundamental rights impact assessment is contextual. You cannot imagine to have a template that you can use in all the contexts. You can imagine to have a methodology, not a template. It's quite different things. Or use a template, just a list of questions in order to create awareness. This is another things. But I don't want to spend more time. If you are interested in the topic, I've just published on SSN a paper that is under peer review about Article 27, how to try to give an interpretation that is more aligned with the European Union values, because this is the matter, and also consistent with the same AI Act that is partially contradictory. In this sense, I think that the experience of Brazilian AI Act is much better, because first, the impact assessment is publicly available. although with some limitations, always has been suggested also by the legal scholars, but is public available. In Europe, we have no public available neither for data protection impact assessment. Is a participatory process. There are many references to the participation. In Europe, we have a lot of concern about participation, including data protection impact assessment. There is a clear list of the stages that, if you look at this strange idea of materialization of risk, maybe a clear list of the stages would be nice also to add in the AI Act. And there is a clear identification of the main risk factors in terms of likelihood, severity, and also the number of people impacted, etc. Something that is missing translation, we can say, in the European version. As well as there is a reference to the precautionary approach that it's true that in the AI Act is materialized to some extent in the prohibition, but not bad to have also some reference in that. So I think that, I think this also, just to conclude, I think that it's not a flow in which Brazilian AI Act copy the EU AI Act, but there is a lot of discussion about how to address the challenge of AI. And I think that maybe if in Brussels, we just look not at the US with a lot of nice journal in a US university, in which there is not a lot of elaboration on this topic, we can go also to Latin America and probably learn more about human rights and fundamental rights and related impact. Just a comment.
Thank you so much, Professor Alessandro. Yeah, so I'd like to move Laura, because we have been heard some similarities, but the main difference between those regulatory approaches in order to strike a properly balance between a rights-based and also a risk-based approach. So I would like to hear from you, Laura, one of key issues about the so-called regulatory interoperability of an AI and how to combine such, let's say, balance between risk and the rights-based approach, and also hear from you, in your opinion, if the AI Act was capable of striking such a fair balance between those kind of considerations.
Thank you, Bruno. Honestly, my take is that it didn't. The AI Act failed to strike a proper balance, but I guess the more charitable approach would be to say that it tried to, and in the end it struggled to make that happen. Fundamental rights, of course, run through the AI Act. They're emphasized multiple times in the recitals and in the operative sections of the Act, which is a welcome thing. And then again, the fundamental rights concerns come through quite strongly in the prohibitions on AI, which have already been mentioned. So there's a dedicated article where there are a few practices outlined which are said to pose an acceptable risk and therefore warrant prohibition. But I think then again, we can take that with a pinch of salt. CDT hasn't been the only civil society organization highlighting that the prohibitions, in fact, could have gone much further. For instance, one example of a prohibition that really shouldn't be read as a prohibition because there are so many exemptions is a prohibition to conduct remote biometric identification. So it reads as a ban, but then the exemptions are so many that you end up questioning whether it's really a ban and whether it's just something that's allowed but subject to certain conditions. And from memory, I think I had a glance of an earlier version of the Brazilian AI Act, and I think the Brazilian AI Act does not couch it as a prohibition as such. I think they're more straightforward in saying this is only allowed in certain circumstances, but I leave it to my expert colleagues to correct me on that if it's wrong. But obviously that does raise the question as to whether or not we took it as far as we could in the text of the AI Act and whether it could have been better. Going back to the framing of the Act, again, the human rights considerations are present in the high-risk category of AI systems. So my co-panelist, Alessandro, has already spoken about fundamental rights impact assessments, which apply to a narrow subset, as he has rightly highlighted, of high-risk AI systems. Still, the intention to protect fundamental rights is there, but then again, it falls short because, as has already been mentioned, it only applies to very few AI systems, and it doesn't apply to the bulk of AI systems, at least statistically speaking, which come just from the private sector and tend not to take on a public role or delegated function, and so fall out of the scope of the provision. if a high-risk AI system or a system posing risk to human rights is included in the high-risk category, at least by reference to the Annex 3, which lists the high-risk category areas, then there's still the loophole question. Many of you in the audience will have looked closely at the AI Act, and you will have seen that reading the provisions, it's not because a high-risk or an AI system falls within a high-risk use in Annex 3 that it is conclusively a high-risk AI system. Indeed, a provider can then assess, based on that initial determination, whether or not their AI is just conducting a narrow procedural task or otherwise, which means that then they can self-assess out of the high-risk category without necessarily having to report this to anyone or actually having that determination be subject to assessment every single time. So what the AI Act asks providers to do is to keep documentation so that they're able to substantiate the decision to downgrade the risk of the AI system. But it's not like there's going to be a sort of iterative exercise with a national regulator for them to double check that that risk category rating was accurate. So in many instances, one can imagine, depending also on how well resourced the national regulator is and what their capacity is, that many high-risk providers will actually downgrade their systems as lower risk and therefore escape some of the provisions of the AI Act. Whether or not they will be found out in due course, of course, will depend on each individual regulator and how well resourced they are to actually proactively conduct these assessments and challenge providers' own assessment of risk. So overall, I would say it's a mixed bag. On the protections for human rights and the AI Act, well, the intention was there all along. There is definitely more that could have been done to make sure that they were better embodied in the text. And I think my colleagues have provided a good illustration of where the Brazilian AI Act proposal has tried to go a little bit further.
Thanks so much, Laura. I'd like to pass to Carolina, because one of also possible indicators to measure in order to strike a proper balance between a rights-based and also a risk-based is also try to identify what are the material exceptions in terms of scope of both laws. So in the AI Act, deal with the development of a use on AI for national security purpose, and also somehow this influenced the Brazilian discussion because this exception also appeared in the latest version of the text. So I'd like to hear from you that kind of specific point, and how do you perceive those kind of exceptions?
Thank you very much. Maybe just to explain, because I'm not on the screen. My name is Karina Iwańska. I work at the European Center for Not-for-Profit Law, which is a civil society organization based in the Netherlands that is working to protect and promote civil society and civic freedoms. And we were involved very actively in the advocacy around the AI Act, also as part of the coalition led by European Digital Rights. And we also collaborate very closely with colleagues from civil society and academia outside of the EU to share our experiences in legislation. And national security is indeed one of those worrying precedents that from the very outset, when it was introduced for the first time, some of you may remember that it was not there in the original proposal by the European Commission. It was not there in the European Parliament text, but it was introduced by the Council and eventually made it to the final text of the AI Act. And it's a very broad exemption. I'm going to go a bit more into the details. But from the very beginning, we were very worried about the fact how this will be perceived as a precedent. Well, you might argue under EU law that there are some, there's a division of competence between EU and member states, so there are some arguments that can start the conversation about the scope of EU laws, but, outside of the EU, in countries that, just regulate technology within their own jurisdiction, there is no such issue. But so we were worried from the outset that discussion in the EU will influence other regulations, and indeed that was the case. Not only in the Brazilian AI bill, but also in the Canadian regulation, also in the Council of Europe Convention on AI. So it really proved to be a really concerning precedent that was just picked up, even when there were literally no reasons to pick it up. Not saying that the EU had the reasons to pick it up, but at least there could be some discussion. So just to explain a little bit more, the AI Act states that it will not in any event affect the competences of the EU member states on national security, even when countries delegate the exercise of such competences to another entity, so even to private companies. And more specifically, the AI Act excludes from its scope AI systems that are sold or used in the EU market exclusively for national security purposes, but also AI systems that are not sold or used in the EU, but whose output is used in the EU for national security purposes. And as I mentioned earlier, this provision establishes a warring blanket exemption from all AI Act requirements for all AI systems that are either created and deployed from the very beginning for national security purposes, or those that are eventually used for such purposes, even though they were originally developed, for instance, for law enforcement purposes. And as I mentioned, it is argued that this exemption is justified by the fact that national security is an exclusive responsibility of EU member states, which is true. But this exemption does not take into account established Court of Justice jurisprudence that consistently held that the mere fact that a national measure has been taken by a member state for the purpose of protecting national security cannot render EU law automatically inapplicable. There are, of course, there could be discussion about justified exceptions from certain requirements of laws if this is justified by national security purposes, but this is not what the AI Act does. The AI Act creates a broad blanket exception where any conversation, just the mere mention of national security automatically triggers the fact that the AI Act will not apply. And so most worryingly, any type of entity, whether public or private, that carries out activities on behalf of the EU government is exempt. And as I mentioned, it also applies to outputs of AI systems. So it is not clear what this output could be. But as a result, in principle, the intelligence gathered by AI-based spyware, for instance, not marketed in the EU, could be used by EU governments for self-declared national security purposes. So there will be a lot of work to clarify that. If an AI system is originally developed or used for national security purposes, if an AI system is developed for national security purposes, and then it is later repurposed or used for other purposes, like for instance, law enforcement or border controls, then the AI system will have to comply with relevant provisions of the AI Act. So that is clear. However, the issue with that is that there is no clear distinction. There is no definition of national security anywhere. So we are very concerned that some member states might use that as a catch-all excuse for evading AI Act requirements or for using systems that are prohibited under the AI Act, like for instance, remote biometric identification, though I agree this is not really a prohibition. And in the context of new and emerging technologies, there is also no clear-cut distinction between national security and law enforcement. For instance, we have seen in the past that governments can argue that some activities of surveillance during public events, like during protests, for instance, when national security is invoked, or in the context of border control and migrant surveillance, that is also already has been discussed in the past. Some member states have raised matters of national security concern. So there is no clear-cut distinction. So this is really, really worrisome that this provision, this exemption will be kind of abused. And it's not clear really what happens if it is, because we will not know, as civil society, as academia, we will most likely not know that it has even been invoked, because there's no database of national security cases that is available to us. In some member states, also I'm from Poland, and Poland doesn't have actually a robust control of national security activities like some other countries do. There is no institution that actually controls national security agencies. So I will pause here and just say that this is very, very concerning. I expect that there might be some legal challenges perhaps to this at some point. I think it will not escape that, because it's simply a very worrying precedent. And what is even worrying is that it really set the tone for the rest of the world. And while you might have very lawyerly debates of what are what is the competence of the EU, what is the competence of member states. As far as I know, Brazil does not have this issue, so I do not understand, what were precisely the reasons of exempting national security, rather than, okay, the EU that did it, so we might also kind of introduce that, because it seems to be already normalized or acceptable that national security would not fall under scope. Thank you.
Thank you so much, Carolina. So back to Elora, how both regulatory initiatives aggravate the vulnerability of underrepresented groups?
Sure. We discussed how they deal with it, but then how they aggravate. So what is missing there? I think the first thing, Laura mentioned a lot of the things that I wanted to touch on, but I think what we have to consider is that the Brazilian society is very different from Europe in general, and the problems that we have there are very, very different as well, and that impacts how we regulate technology. So Brazil is one of the most unequal countries in the world, and racism, for example, is it's a systemic issue, with Black people not only being disproportionately affected by surveillance, by police brutality, but also by more severe economic issues. So public safety is it's a real problem there, and that means they were probably more keen, or at least the authorities are more keen on using more technology to solve the issue. And as I said, this reflects how we regulate technology. So when we're talking about prohibited practices, for example, there we have important prohibitions, but with lots of exceptions. So as Laura mentioned, one of the most problematic one is real-time remote biometric identification. Indeed, in the first proposal, it was was kind of a moratorium with the possibility of including of having a law that would regulate this. And then there they say, okay, this is possible, but now in the latest version we don't have the moratorium anymore, but we have this prohibition, which is not a prohibition, as you mentioned. So it's banned for law enforcement, public spaces, and if it's remote, so it's the same for the AI Act. But it's still possible to be used by other public entities, by private actors. It could be used retrospectively, which is as problematic as real-time systems. And of course, we have all the exceptions that the AI Act also have, which is also problematic. And we know that these systems are less accurate for children, for Black people, for women, people with disabilities. So the vulnerability there is also aggravated. Another problem that I mentioned before is emotion recognition that is only banned for workplace and education. In the AI Act, we don't have any prohibition whatsoever in the Brazilian one. Also, predictive policing in the AI Act is only prohibited if solely based on profiling. As far as I could understand, and correct me if I'm wrong, Bruno, in the latest version, because the language is also not so easy to understand, I think it's at least prohibited in any case. So in this, I think the Brazilian one is a little bit better. And of course, none of the bans that we have in either of the acts meaningfully apply to the migration context, which we know is basically creating a different regulatory framework for migrants. Of course, in Brazil, I wouldn't say that the problems with migration, they're not so bad, but of course, this should not be disconsidered because, we don't know the future. And of course, the problem with all of this is that basically legitimizes practices that are not necessarily proportionate when it comes to human rights interference. We're talking about human dignity, non-discrimination, presumption of innocence, etc. And then we understand that there are some practices which should be banned, but they are being they can go through conformity assessment and receive and become CE marked. So when it comes to high-risk AI systems in the Act, we also have this loophole that was also mentioned by Laura on Article 6.3, which basically gives developers the possibility to exempt themselves from the obligations if they consider that the system is not high risk. Of course, this could be checked ex post, but it's a loophole in this sense. Another point that is that within the Brazilian bill, we have this very important section on the rights of people affected by AI, which is already a great advantage when it comes to the AI Act. But I feel that some of these rights have been kind of watered down in the latest version, because before we have all the rights applicable to any person that is affected by an AI system, while now we have this differentiation between some rights that are applicable to all, some rights that are applicable only to people that are affected by high-risk AI systems. So I think that there we're really missing the opportunity to really implement the values that I mentioned before that are on Article 2, and really close the gaps that were identified, that are being identified within the AI Act. So one clear example is when we're talking about education, for example, in the Annex 3 list. Since the Brazilian bill, the provisions that we had from the AI Act in the Brazilian bill are mostly from the proposal. Some of the issues that were corrected during the legislative process here were not corrected, I think, in the Brazilian one. So as I mentioned there in the list, now in the AI Act we have basically 4 subcategories for education, just one example. We're talking about systems that are used for providing access or admission to education institutions, evaluating learning outcomes, and these 2 are in the Brazilian AI Act as well. But now, for example, we have also included in the AI Act, the European one, systems that assess the appropriate level of education that an individual can receive, and also systems that monitor, detect, or prohibit behavior of students, so basically e-proctoring, and these 2 are not there, which are also important. So I think the most important thing now is not to follow the European approach in terms of rushing the process, to take it easy and make this as democratic as possible, because we still have a lot to discuss there, and make this regulation the best version that it can be.
Thank you, Elora. So I'd like to back to Laura and also hear from you some positive view of the practical solutions that the AI Act provide for individuals affected by the use of AI systems.
Thank you, Bruno. And I think here again, I'm going to be raining on the EU's parade when it comes to the AI Act. The reason I say this is, as some of you will have seen or know, the AI Act has a remedies section. But truthfully, I think that to call it a remedies section is quite generous. The reason why I say that is that, you know, we've worked on a series of digital policy files in the EU, most notably in the past GDPR, and you can tell that there's a really stark difference between the remedies section in the AI Act and also pre-existing EU legislation. Which makes it quite noteworthy in that we ask ourselves the question, why did we depart from what we did before? So 2 key things in the remedies section in the AI Act. The first one is the right to explanation after a decision has been made, supported by automated decision-making. Automated decision-making in the EU, when it produces legal or significant effects, is banned already, and this is the position since the GDPR came into force. So the AI Act doesn't deal with that precisely because it has already been done. But the AI Act, however, foresees that automated decision-making will be used to support, to some extent, decisions being made by humans. And so the AI Act creates a right to explanation, but only if individuals have been legally affected by the decision or have encountered significant effects. So again, they're borrowing from the wording that was in the GDPR to prohibit automated decision-making, but then that really narrows down the circumstances in which an individual will have an effective right to an explanation if they have to show first that they've been significantly or legally affected. So it is a good thing that it's there, but it could have been phrased in a broader way to create a broader right. Closely related to that, there's the right to lodge a complaint, also included in the AI Act. But then the question is, how effective is this right to lodge a complaint? Because the AI Act creates no obligation on the regulator, so in this case, the Market Surveillance Authority, to actually do anything about it beyond take it into account. And it is understood that the reason why the AI Act doesn't go into so much more detail is because domestic legislatures will have their own debate and decisions about exactly what the powers of a market surveillance authority are and what is going to be their capacity and the way in which they receive and deal with complaints. But then again, I can't help but to go back to the GDPR, where there is an obligation on data protection agencies, so a whole different beast, to inform the complainant of the process that their complaint is going through, update them on the outcome within a reasonable period. The GDPR doesn't go into a lot more detail beyond that, but at least it just forces the relevant authorities to engage with the complainant and to give them a result. Similarly, the GDPR creates an effective judicial remedy against decisions taken by a data protection authority. There isn't anything like that in the AI Act. And there is a right to effective remedy enshrined in EU law already in the Charter of Fundamental Rights. And it's quite salient that nothing like that has been replicated in the AI Act either. Now, full disclosure, as many of you will know, there is another legal initiative going through the EU Parliament at the moment, the AI Liability Directive, which is expected to deal with many of these questions. But then again, the process has been somewhat in suspense since the AI Act was finalized, even though it was meant to be picked up once the draft text was agreed on or at least approved. So it remains to be seen whether or not the AI Liability Directive will deal with all these points satisfactorily. But even if it did or it didn't, it is quite interesting that the AI Act hasn't gone as far as to reiterate some of the things that are already known in EU law and that are well-accepted principles of effective remedies. So I think I'll leave it there. I think it'd be interesting to look into the Brazilian AI Act and how it provides for effective remedies and how many other rights it creates in effect, because these are just the only rights that are created for individuals in the AI Act. And I get the sense that there'll probably be more.
Yeah, and also in terms of topographic analysis, because like the Brazilian regulatory proposal, after the principles and the conceptuals, put a chapter on the rights first instead of obligations of providers. So it's also something legalese, but means a lot in terms of regulatory technique. So I would start by analyzing somehow the structural part of the law. But moving to local or regional policy conversations, to global policy conversations, we have seen a lot coming from UNESCO, from OECD, also the recent resolution at United Nations, and this year specifically, we are having G20. Brazil holds the presence of G20, and apparently AI must be one of the priorities. President Lula is pushing for it, so we are also hoping a stronger speech of him at the General Assembly of the United Nations in September, and then after, probably in November, we must see something related to AI, hopefully in the final declaration of G20. And I would like to hear from you, Professor Alessandro Mantelero. I'm aware that you submitted also a policy brief in that regard. How do you see the upcoming G20 final declaration or summit in Rio de Janeiro in Brazil? What possible recommendations should be adopted for the governance of AI and the promotion of its human rights-centered development?
Thank you, Bruno. I think that the G20 is a good, great opportunity for many countries, because it's emerging this situation in which the large part of the countries have not the power on AI. So AI is largely developed by third countries, and we are largely adopters of AI system. So, of course, this is not a critical issue. It's like technology works in many cases, but this arises from in many countries the concern about how to shape this technology in order to align the technology with the society, because AI is not like electricity, although electricity also impacts social consequences, but it is much more in terms of embedding values and transferring values through the way in which shape the world. So for this reason, I think that in the G20, many countries, probably not the giants in the AI production, but many countries from both the north and the south of the world are interested in order to fix some guardrails, as said by Victor Manschamber or other colleagues, so some barriers in order to shape the path for the AI, in order to have an AI that is not a global AI, but it's a contextual AI. I think that this early stage of a global solution for AI is nice, is normal, but now we have to ask more. If you want to provide the services in Europe, in Brazil, and many other countries, you have to comply with these values. So in this sense, I think that a powerful instrument, of course, is given by the impact assessment. The fact that the Brazilian AI Act, the European AI Act, the Canadian proposal, and many other proposals focus on impact assessment is also something that should be further elaborated in the G20. So it's nice to have the idea that impact and risk are important, but it's also nice to have some ideas how to carry out this impact. So working more on the methodology, because if you look at what happens around, we can say there are a lot of confusion about the methodology. For instance, there are some models in which the variables are not used properly. For instance, the model from the Alan Turing Institute that was released some couple years ago have a lot of confusion in terms of some variables and the quantification of the impact, or the Dutch model that is quite well promoted, that is focused on the why, how, and what model. That is a model that not fit perfectly with the circular approach that we use in risk assessment. Why is important the methodology? Because the risk assessment in AI is not something that is invented by the legislator. It's something that should be consistent with the methodology of risk assessment. Because the company cannot have a strange risk assessment for AI and the rest of the risk assessment for all the activity of the company. So if we don't follow the approach of risk assessment that is the basic of risk assessment in all the fields, we create something that is not consistent and also difficult to be managed. So in terms of takeaway, what it means that we should use variables, but the correct variables that are relevant. For instance, in the Canadian model of impact assessment, these variables are not clear. There is from 0 to 5 points, but it's not clear why it's from 0 to 5 for some answer and from 0 to 3 for another answer, etc. So transparency about the use of variables is a key element of all the system. A second element, in many proposals of impact assessment, there is a cumulative approach. So how is the overall impact on fundamental rights? But fundamental rights are not overall assessed. Each right should be assessed by itself. You cannot compensate, okay, this is quite impactful on privacy, but has no impact on freedom of expression, so it's nice. You cannot do that. If there is enough impact on one right, you have to address this. The third point is, in many cases, in some proposal of impact assessment, there is a fragmentation of these rights. So it means that they are counted 2 or 3 times because they are not properly framed. Or are missed variables. For instance, the Dutch proposal focuses on severity, but miss probability. Fortunately, in the Brazilian Act, but also in the definition of the European Act, there's a clear basic idea that risk assessment is based on likelihood and gravity or severity. So that's a common knowledge in terms of risk assessment. Another point is that we have to work more on the operationalization in terms of accountability of risk assessment. Risk assessment is not a template as suggested by the Commission, unfortunately also by the legislator in Europe, but is a methodology that have to provide evidence and accountability. To be accountable, what it means? It means that you have to create systems in terms of risk, a typical matrix of risk or something like that, in which you show why the combination of likelihood and severity lead to a specific evaluation. Because it's like in data protection impact assessment, it's not just your opinion about the level of risk, it's not just a kind of evaluation, yes, maybe impact on these rights and other rights, but it's assessment, evaluation of level of risk, and mitigation. So to mitigate, it means that you have a prior and an after moment. So the risk is high, after the mitigation is low. But it's not based on your words, on your idea. You have to show that also from an evidence, so you need some methodology that are well known in the field of risk assessment that are typically based on matrix, but there are also other solutions that show what is the impact of the measure that you have adopted. So I think there is a lot of room for this discussion about the methodology, and it's not just a Brazilian or European, but it's a global issue. And the last point, I think that also in G20, based also on what was the UNESCO report, is not just a matter of fundamental rights. Because also in Europe, after spending years discussing about ethics of AI, then decide that now it's just a problem of safety, security, and fundamental rights. But still there are problems of social ethical impacts, and still social impact should be considered. So an holistic approach to impact assessment, a multilateral approach is crucial, because what is legal compliant, it doesn't mean that it's socially acceptable. And this is something that should also assess with the other instruments that are specific for ethical and social impact assessment, but this is also part of the issue that we have, because techno-solutionism in many cases is legal compliance, but it's not necessarily the best future for our society.
Thank you so much. Yes, one of the deliverables that was highlighted by the concept note that was pushed by the Digital Economic Work Group in the Sherpas track, the government track, is kind of a readiness map toolbox in order not only to evaluate the capabilities and also possible diverse data sets in order to avoid discrimination and so forth, but possibly what are also the capabilities of having capacity building in terms of having a substantial or minimal procedures to have like a social impact assessment in that way that you highlighted. Yeah, so moving lastly to Carolina, how do you see the interplay between those global policy-making arenas considering G20 and also the Global Digital Compact that is coming in September? And also, it's important to highlight that next year we are going to have South Africa holding the presence of G20. So it's like a unique political momentum in G20 in terms of having a South-South troika. So it starts with Indonesia, then India, Brazil, and South Africa. So I would like to hear from you also that kind of geopolitical interplay.
Not sure if I can deliver that, but indeed, like there's much more happening on the global level when it comes to AI. You mentioned a number of initiatives from the UNESCO principles to the first UN General Assembly resolution on AI, and now also the Global Digital Compact, which is something that we are following quite closely. And in general, I think it's extremely valuable that there are these attempts to harmonize the approach globally and try to create a less fragmented kind of framework for common standards, especially for protection of human rights under the International Human Rights Framework. And there are a couple of things that I would like to point out as maybe like concerns or things to reflect on. One is, I think I would repeat a little bit what Alessandro already said, that there is a slight concern about the proliferation of these high-level principles without operationalizing them, without creating clear mechanisms, without duplicating existing mechanisms as well, to make sure that, okay, how do we actually translate those high-level principles from various instruments, from various declarations into obligations that actually protect people in different countries. And also in that respect, how do we make sure that civil society is a key element of those discussions? For instance, when you look at the draft of the Global Digital Compact, it already includes a lot of references to multi-stakeholder bodies, but it could still use a much more emphasis on the participatory aspect of governance. And here, I feel like it's specifically human rights expertise as well, because very often when different bodies are being created in terms of advisory powers, there is a lot of emphasis on technical expertise, which is of course important and should be there. But I feel like there is not enough emphasis on expertise in human rights, expertise in societal impacts of AI. So, so this is something that I think this global approach should really prioritize to make sure that, because ultimately, as colleagues have said on the first panel that I attended this morning, it's not really about technology as such. It's really about how technology is used to govern power relations in society as well. And here, specifically for for civil society and human rights expertise, another trend that we're seeing in those global approaches is that more and more technical standardization bodies are getting a lot say in how those governance approaches, risk management systems are going to look like. The IEEE, ITU, all these different institutions that to me still seem very opaque and very inaccessible for civil society, historically without much human rights expertise, historically without engagement with stakeholders. So this is, if indeed that's the direction, that if indeed the way that these broad principles are going to be operationalized is through those standardization bodies, then, I'm not necessarily agreeing with this approach, but if this is the consensus, then for sure they have to be reformed to ensure that there are strong civil society voices there, including civil society from global majority countries, who also have very difficult access to those institutions. And another aspect I think that is worth highlighting is to ensure that these global approaches are properly contextualized within different national contexts. So because of the fact that the EU AI Act, maybe the Council of Europe, they are very concrete examples of approaches, they might have very strong influence on the global mechanisms. While operating possibly in very different contexts. So for instance, we have a lot of criticism on this panel for the AI Act and how it fails human rights, in fact. But AI Act doesn't function in a void, it functions in a kind of an ecosystem of underlying EU legislation, including the Charter of Fundamental Rights, data protection regulations, non-discrimination laws. So there is kind of an entourage of various legislations that can also be triggered to make AI Act stronger, to fill in the gaps that the AI Act possibly leaves, to give the voice to civil society, to affected people. But in many regions of the world, this is not the case. So it's also important to ensure that those global approaches, that they also, do not regulate AI or talk about governance of AI, because, obviously it's a very trendy topic currently, but miss the kind of ignoring maybe those fundamental data protection issues, for instance, non-discrimination issues, actual respect for international human rights frameworks, that to me they create a base for any successful AI governance on the global level. And the last thing I wanted to point out is that specifically for the Global Digital Compact, I don't think per se it's a bad document. Having read the first version, there is a revised version as well, following some comments from countries. It appears quite grounded in international human rights language. There is a lot of reference to international human rights, but there are very striking omissions, I feel like. For instance, in the first version, there was a very weak, but there was a reference to surveillance and how surveillance has to be in line with human rights. It has been, not only it hasn't been improved in the revised version, it has been further shortened and just okay, surveillance, bye, let's move on. So that is, I think, also indicative of this broader trend of securitization and creating exceptional frameworks for security uses of AI, or even equating security with the use of AI. In particular, something that really struck me, I'm not surprised, but I wish it was there. There is no single reference to the possibility that there can be uses of AI that are incompatible with the international human rights framework, and that impact assessments can lead to the conclusion that actually some systems should not be deployed, some systems should not be used. I do not expect as much of maybe this kind of global regulation to actually list what those systems are. It would be, obviously on my wish list, but I think this is in the current climate probably too much to expect. But even just a reference to potential, because the Global Digital Compact will also create new fora for discussion and so on, and giving them a specific mandate to deliberate, okay, what are actually the uses of AI that are incompatible with human rights, that could be, I think, very useful. But I don't know if we can get there.
Thank you so much, Carolina. So I'd like to open for questions from the audience. In the meantime, if you just could put the slides. Michael, Humor. Okay, okay, so start with it.
Thanks. Just I guess a quick question about remedies and the difference between EU AI Act and the Brazilian proposals. We know the AI Act in EU didn't confer any rights to individuals, and now the ones it confers are a bit of a mess anyway. And also the regulators themselves are going to be very important, and yet it's going to be very difficult for them to ever make a decision. They're so far away from doing that in the AI Act and so far away from enforcement in practice that it's hard to see how clarification will get to a court. If you have more direct remedies, things can get to courts a bit more easily. How does that look like in the Brazilian cases? Does the current text indicate that courts might have an ability to clarify things more quickly than the EU AI Act? And has that been an area of contestation?
Mm-hmm. Yeah. One more from there.
Hi, I'm Laura Linkomies from Privacy Laws and Business. So I have a question about the regulators. Understand that in Brazil, the current data privacy authority hopes to become the AI authority, whereas in the EU, I think there will be fragmentation. So some countries might have the current data privacy authority, some countries something completely different. So how do you see this impacting future international cooperation?
Mm-hmm. Thank you.
First short question. I'm from Japan. In Japanese, there is no regulation about the AI Act now. The Japanese government is tend to the soft law approach. Which do you think about this kind of approach compared to the its interoperability? If you have a comment, please.
And then I think we can.
Hi, thank you. I have a question about the role of the emerging South-South cooperation for global policy making that influences regulatory interoperability. And while I do agree that there is a South-South cooperation emerging in the G20, the developmental priorities and the commitment to fundamental rights in each of these countries is very different. India's commitment last year and this year is very different from Brazil's commitment to rights. So I wonder then, what is the role of like the local and the regional in addressing these kinds of fragmentations in developmental priorities in the South?
Yes.
Thank you. Thank you so much. I have a question regarding the role that standardization plays in the AI Act, and how could it be combined or embedded in this fundamental rights discussion?
Yeah. So, one more. And then one more hour of the panel, and then we can answer the question.
Okay. Hi, good morning. My name is Isabela Câmara. I am a lawyer at Souto Corrêa in Brazil. So considering that the Brazilian law is more from a right-risk approach, would you understand that it's more adaptable to new technology? And how would Europe deal with this new technology that are not categorized under the current AI Act? Thank you.
Thank you. So before to pass the floor for our panelists, I'd like just to invite all of you to access this report that was recently translated to English. The first version was released in the end of the past year. It is co-authored by Paula Guedes and also Marina Garrot and myself. And our aim was to try to organize the normative concepts in some kind of regulatory initiatives. And one of key finds is how we are moving towards regulatory interoperability, but without having a regulatory colonization. And one of the key finds try to organize mainly what means a risk-based approach, the conciliation with rights-based approach, and also trying to identify that at the end of the day, we're having a discussion about how much democratic regulatory ecosystems we are framing. So we can see very large difference between those regulatory initiatives that were mapped in this report. Before to pass, just to take one of the, or two questions that were made with regards to the enforcement. The latest text provides the so-called CIA, the governance AI system. So try to have a kind of harmonization between some regulator that would coordinate the system, and also pushing and creating incentives and nudge for sectoral regulators to enforce AI, considering in health, finance, and so forth. Also, one thing that is interesting in the latest version is that they kept some kinds of rights provision, and one of them is the collective redress that are, let's say, assigned in other legislations in Brazil. So indeed open the avenue for courts addressing this issue. Of course, it's not like the primary objective in terms of interpreting the law, but it's like quite possible, and it's already happening in Brazil, because the two big cases that we had there are related to facial recognition, and the judicial courts take down those systems in the Brazilian subway under the arguments of other possible human rights violation that are not considering the upcoming regulatory initiative on AI or the rights assigned by this future regulatory initiative. So I'd like to pass the floor for you guys. I'd like to start.
No, I'm not sure if I have taken notes of all the questions. Yeah, I was thinking of the question that you already answered, and I think it's also good to say that within the latest version, as you said, we kept this possibility, and also that it's without prejudice, so you don't have to go to the competent authority or the system to lodge a complaint. You can go directly to the courts if you think it's more appropriate. Yeah.
Okay. I think Carolina would like to take the question about the standardization, right?
Yes, happy to address that. So indeed, standards have a pretty big role in the AI Act, because they, we're talking about harmonized standards, so standards that have been approved, and they create a presumption of conformity. So they are indeed very important, and there are two issues I think that civil society in particular has with that approach. The first one is that there is a huge domination of technology sector in the standardization bodies and CENELEC. There is a historical lack of fundamental rights expertise, while a lot of these standards will actually touch on fundamental rights issues, even the way that you define bias, the way that, standards will also standardize the risk management approach, which also includes assessing, mitigating risks to fundamental rights. So there is a question of to what extent there is expertise within standardization bodies to address that in a competent way. So the answer might be, okay, so why doesn't civil society and human rights experts participate in it? The problem is that the barriers to formally join CEN and CENELEC are extremely high. My organization does not meet the conditions to join. There are a couple of ways. One way is to join through the national standardization kind of delegation to CEN CENELEC, which is also very, very difficult. There are just a bunch of civil society. There's a consumer protection organization represented, trade unions, and that's basically it when it comes to representation of civil society in the standardization processes. So even if civil society joined, it would still be like 3 to 1,000. So that's also obviously very, very draining on civil society capacity. However, there has been the European Commission standardization request obliges CEN and CENELEC to ensure that there is human rights expertise and to engage with different stakeholders. To this moment, I think it has not been done very well. However, there has been created a group on inclusiveness that technically is available for anybody who wants to provide comment, as well as a specific task force that was created for fundamental rights. So there is an idea that this task force would participate in different processes to see what are fundamental rights concerns along different standard deliverables, and kind of supplement that with fundamental right expertise. But all of that relies really on specifically colleagues from trade unions who are proactive about consulting with some civil society. Formally, there are no structures really for that. So I think this will be very important later on when standard deliverables are produced next year. I think how, whether it will be possible to raise concerns about things that maybe they do not address or do not address sufficiently, so that perhaps they are not adopted, as some of them might not be adopted as harmonized standards. But again, there is also an issue because it's the European Commission who decides, which is also, I guess, problematic from the governance point of view, but it has to consult the advisory forum on that. And the advisory forum does have some civil society, at least it's supposed to have some civil society representation, but we will have to see in practice how that works.
Alessandro, Laura, please.
Yes, just a couple of quick comments. We regard Japan, based on my experience in the Council of Europe, I was an expert in the KAI committee for the new framework convention. Japan always adopted an approach focused on soft law, and this is also based on the fact that it's more consistent with the national approach, we can say. Of course, in terms of interoperability, this might be an issue because it's a different kind of approach. I think that the co-regulation that is adopted in Europe, but is also adopted at international level, can be a way in order to combine the two aspects, so hard law and soft law. And also because some aspects, such as those we mentioned about other impact not related to fundamental rights, are typical instrument of soft law. Just a quick comment about standards. I think that we have not to follow the Commission in overemphasizing the standards, because we have two processes of assessment: conformity assessment, fundamental rights impact assessment. In the conformity assessment that should be carried out by the AI provider, there is also the cluster of fundamental rights. For this kind of assessment, conformity assessment, is envisaged, we can say, in the regulation, the role of standards. But for the fundamental rights impact assessment carried out by the AI deployer, there is no standards. It's not considered to use standards. So it's not all standard-based. And also with regard to the part of standards, there is a problem of methodology, because standard, by definition, by the words that we use, are based on the fact that you standardize something that is always the same. If you use an AI that is used in order to recognize the people, and use this AI in a school, in a street, in a public space, in a high-risk high-rate crime zone, etc., is different. So how you can imagine to standardize this? The only way is methodology. So standards in terms of methodological standards. I hope that the Commission understands this distinction and works more on methodology than with the idea they have a very precise and detailed standard that is rather impossible. So there are some differences that you have to keep in mind about what it means standardization in AI.
And just one quick note to end, because I know we're running over time. I'll take quickly the question about the market surveillance authorities and how different approaches by different national regulators might lead to a little bit of a dissonance, I think, at regional level. I think that's definitely true. And it will remain to be seen how these different market surveillance authorities are regulated and how they're created, with what powers, and also who they end up being made up of. I know that many countries are planning to use their traditional market surveillance authorities that have been created to regulate telecoms or toys even, and there's a thought about making these delve into the AI arena. Whether they have the qualifications and the skills to do so is a different question.
Thank you. Thank you so much. I think it was a really fantastic panel, deep dive. Thank you so much. So applause to our panel.